who's based at the University of Glasgow, and at the Institute is the Economic History Society Fellow, one of the Economic History Society Fellows that society very generously sponsors at the Institute. Hannah's research explores violence, law, and constructions of criminality in 19th century Scotland. And she's currently developing, having finished her PhD, a monograph based on the doctoral thesis, as well as further archival research into the judicial and cultural responses to female violence in Scotland in the late 19th and early 20th century. And Hannah's paper this afternoon is entitled Criminal Types, Gender, Violence and Society in Scotland, 1850 to 1914. So welcome, Hannah, and over to you.
Thanks, Philip. I'm just going to share my screen, just a tick. Hello, everyone. Thank you very much for coming. So as Philip just said, I am the EHS Power Fellow for this year, working on a project called Criminal Types, Violence, Law and Society in Scotland, 1850 to 1914. So I've only been doing this project for 4 weeks, so please don't expect any grand conclusions just yet. But what I am going to do today is outline what this project aims to do, contextualize this within my previous research, and then talk briefly about some of my initial findings over the past month. I'm going to include a brief content warning here. There are some discussions of sexual and domestic violence in the context of criminal prosecutions. So as an overview of this research project, the overall aim of this project is to conduct a comparative gendered analysis of judicial and cultural responses to violent crime in Scotland between 1850 and 1914, which, as Philip said, will be the foundation, hopefully, for a monograph on this theme. So this year, I'm going to be analysing prosecutions of women accused of a range of violent offences and compare this with my previous research into male violence. And I'm asking, how were women accused of violent offences treated before the law and regarded within wider society in comparison to their male counterparts? And by adopting this comparative perspective, comparing male and female violence, I seek to ask new questions and delve deeper into the relationship between criminal justice and wider society, and explore in greater depth the extent to which gendered and cultural constructions of criminality more widely influence judicial and societal responses to a broad spectrum of violent offending. So before going into more depth about this new project, I'm going to add some context here and show where it originated. So the key project is an extension and development of my doctoral thesis, The Legal Regulation of Male Violence in Scotland, which probably gets a prize for the most boring title for a thesis on violence and criminality, but anyway. So this thesis explored a broad range of violent offences, domestic, non-domestic and sexual, across a spectrum of severity. So whilst homicide is often taken as the marker for levels of violence within a given society, it's not necessarily representative. My thesis explored judicial and cultural responses to male violence, from everyday assaults and breach of the peace, which just strayed beyond the boundaries of tolerable content into criminality, to the more exceptional, severe capital offences such as murder and rape. And I had 3 main conclusions from my thesis. First, that ideas about gender, social hierarchy and status, ethnicity and notions of respectability had a notable effect on judicial responses to violence. So it's well established within historiography that working class men were more likely to be accused and convicted of a violent offence than other men during the 19th century. Yet what I was able to show is that there wasn't a uniform experience within this broad socioeconomic class. For example, men working in semi or generic manual labouring occupations were twice as likely to be convicted of rape than working class men working in non-labouring occupations. In terms of ethnicity, Irish-born men constituted 16% of men prosecuted for murder between 1850 and 1914, yet made up 44% of those convicted and executed for the offence. And I think in this we can see prejudicial stereotypes of the intemperate and violent, brutalised Paddy playing out within judicial outcomes. There are 2 other key conclusions that I drew out of my doctoral research interrelate in many ways. So first, that there were distinctions between the law in theory and its realisation in practice. And second, that antagonisms existed between judicial intentions and public responses which influenced judicial outcomes. And this relates to the idea that it's not just judicial officials who shape the outcome of criminal trials. As an example of this, in 1897, John McLachlan was tried for the murder of his wife Annie, who John alleged to have been a habitual drunkard and that her actions prompted and provoked his fatal violence. Now, the judge in this case favoured a verdict of culpable homicide. So culpable homicide in Scots law is roughly equivalent to manslaughter in other jurisdictions. He based this assessment on the provocation that John had registered in his defence, which the judge argued reframed the violence in this case as that which was partially excusable or mitigable, but still punishable. Yet the jury acquitted John with a verdict of not proven. A press report covering the trial registered the judge's dissatisfaction with this verdict. Gentlemen, I am glad that's your decision, not mine. So where does this new project fit into what I've done previously? Well, I mean, it's actually the result of my PhD viva in January, where I found out that 90% of your viva is actually spent defending what you didn't do rather than what you actually did. And I was asked by my examiners, if I'm trying to conduct a gendered analysis of responses to violent crime, well then why hadn't I adopted a comparative perspective that incorporated female violence and the female experience? And that's what this new project seeks to achieve. So I'm going to analyse High Court prosecutions of women accused of murder and Sheriff Court prosecutions of women accused of violent offences. And these will be subject to quantitative and qualitative analysis and compared with the data I've already amassed for male violence. At the same time, I'm going to use press reports and other forms of social commentary to access ideas about female violence, whilst contextualising these judicial outcomes within the theoretical basis of Scots law. And in addition to the main research questions that I outlined earlier as to the comparative treatment between male and female offenders, I'm interested in the following broad questions. So how were allegedly violent women regarded within law, in the courtroom, in wider society, and to what extent did this change over time? Were certain women more readily associated with violent criminality than others? And did this align with the male experience? And to what extent did judicial and societal attitudes differ or correlate? Now, as I outline these research questions, it's worth bearing in mind that dreaded "so what" question. Why is this research necessary? And here I would point to three main elements. First, that gendered analyses of 19th century crime have tended to focus on either male or female violence, rather than adopting a comparative perspective. Second, that female violence brought before the lower level courts, which were much more numerous and arguably more representative of female offending on the whole, have been afforded very little attention. And then finally, the Scottish context has too often been relegated to the margins of historical analyses of crime, seen as a peripheral consideration of Anglo-centric British studies. Now, what's striking about this last element is that it overlooks the incredible quality of the Scottish source material. So yes, Scotland has a separate legal system that'd be quite difficult to get your head around. For instance, in Scots law, you use the term assoilied instead of acquitted. But what you also get is an incredibly rich and detailed set of legal records that facilitate an engagement with a much broader picture of criminal justice. So here in particular, I'm referring to High Court precognitions. These are pre-trial documents. So High Court precognitions contained extensive witness and victim depositions, often numbering over 100 pages in a single case, declarations of the accused, and medical reports of injuries sustained by victims. 90% of these pre-trial depositions exists in Scotland for this period that I'm looking at. And this is compared with 2% of the equivalent records, English and Welsh Assize trials, for the English and Welsh context. But precognitions contain even more fascinating insights into criminal justice. On the left of this slide, I've got a document that was found in the precognition of 5 men for the rape of a mill worker found drowned in the River Eden in Fife in 1853. So this document is actually an anonymous letter that was sent to Cooper Police 2 weeks after the woman was found, and after initial police investigations had actually found no evidence of foul play. This letter explicitly named the 5 men involved and kick-started an eventual prosecution. But also within these precognitions, we get communications between the legal agents for the prosecution. These are lengthy letters that discuss charges, what evidence they have at their disposal, and also the character and reputation of both the accused and the victims. So in the rape case I just mentioned, within the precognition, there were a series of letters between the agents for the prosecution where they outlined that they didn't feel they had enough evidence to pursue a prosecution of the 5 men implicated in this offence. The chief prosecuting officials tell the local prosecutor to select 2 of the accused to turn Crown's evidence, so to testify against their accomplices in return for immunity from prosecution. And these letters outline this selection process should be based first on relative degrees of culpability or guilt, but also take into account the character of the accused. I've got an example of these forms of letters actually on the right-hand side of the slide. Now, this is actually a sodomy case from 1836. But this case involved a male schoolmaster accused of sexually assaulting juvenile male students over a period of 20 years at his school in Infanticide. And in these letters between the prosecutors here, what we see is that there's a considerable hesitancy in pursuing a prosecution, despite considerable evidence in support of the indictment. Indeed, there's discussions within these letters which encourage the local prosecutor, the procurator fiscal, to tell the accused that if he leaves the country, then a prosecution will not be further sought. And the nature of these Scottish sources actually directs my methodological approach and helps to inform my findings. Because rather than simply focusing on the outcome of judicial processes, on conviction or acquittal, the Scottish records allow a much more in-depth engagement with the processes from initial police arrest to the complex legal entanglements and manoeuvring that preceded the trials, as we see in these precognitions, the point at which a male or female accused was subject to a judicial outcome, and then even beyond that. So whilst this is a study on Scotland, the inherent value of the Scottish sources also provides an insight into the relationship between law and violence that is relevant beyond the Scottish context. So as I've said, I'm not just interested in extreme fatal forms of violence, but also in more everyday forms, more common forms and less severe forms. So when the archives reopen at some point in the future, I'm going to analyse both summary and solemn sheriff court procedure, and I've outlined the differences between those on the slide. Now, these trials provide a vast amount of data which can be used to conduct quantitative analysis of these more common forms of violence. So the sheriff courts not only tried less severe and less exceptional forms of violent conduct, but they also tried many more cases. They were much busier courts. So while 701 men were tried for murder between 1850 and 1914, the same number of men were tried for violent offences in just 7 sampled years in Glasgow, Aberdeen and Dundee solemn sheriff court trials. And at summary level, this lower level, these were cases tried before the sheriff alone and with offences of a lesser severity. Over 1,200 men were tried in Aberdeen Sheriff Court alone between 1850 and 1866. And to give an insight into the type of information that I can access, I've got a horribly Frankenstein graphic of my Sheriff Court database at the bottom of this slide. So as I hope you can see, in one case, you can get a huge amount of data. So occupation, type of offence, use of weaponry, details of the offence itself, the special defences offered on occasion, as well as the ultimate result of the trial. And this sort of data allows for direct comparison and provides a means to assess whether the experience of female offenders tried before the sheriff courts aligned or differed with that of male offenders. So at this stage, I'm going to talk a little about some of my initial findings from the first 4 weeks of this project. So far, I've used the very useful National Records of Scotland catalogue of High Court cases and press reports to assess women prosecuted for murder between 1850 and 1859. So in this first 10 years of my period, 219 people were tried for murder before the High Court. What's surprising is that 47% of these people were women. What is perhaps unsurprising is that the majority of these cases involving women accused of murder were for infanticidal crimes. 78 out of the 95 cases involving women were for child murder. Now, the infanticidal mother is a dominant trope in the histories of women's criminality. And the statistics from this early analysis certainly indicate that infanticide was indeed one of the more common forms of homicide that women were accused of. Yet in a project that aims to compare male and female violence and their responses to the criminal justice system, I've encountered evidence that this can actually be used by violent men to their attempted advantage. So I've got an extract of a press coverage of a 1907 trial of William Mitchell. So William Mitchell was a widower who got his unmarried housekeeper pregnant, and then according to the trial evidence, when the child was born, threw it out of the window, fatally injuring it, and then tried to use the infanticidal mother trope to pin the blame on the child's mother, his housekeeper, Gertrude Grant. Now, in this instance, it was an unsuccessful defence. The presiding judge, Lord Maclaren, said in sentencing that by his seclusion of his paramour for nearly 6 months, by his neglect to furnish her with any assistance at her confinement, and by his threats to desert her, he tempted her to do this criminal act. And on finding that she had resisted the temptation, he himself, in a callous and cruel manner, took the life of the newborn child. He, the accused, was prepared to give testimony that might have led the girl he was bound to protect to swing on the gallows in order to save his own neck. Now, returning back to these child murder cases, I think what's clear here is that there's a relatively high rate of conviction. So 79.4% of these child murder cases returned a guilty verdict. By comparison, between 1850 and 1914, just 70% of trials of men for murder resulted in a conviction. Now, in Scotland, when a man is accused of murder in Scotland, the jury had a few options when it came to returning a verdict. They could return a verdict for guilty of murder, the capital charge, or they could return a verdict of guilty for the lesser non-capital offence of culpable homicide, which, as I said, is roughly equivalent to manslaughter. Or else they could return a verdict of guilty for another charge if that was included within the formal charge in the case, for instance, concealment of pregnancy. And hopefully you can see from my tables, an overwhelming majority of convictions of women in these trials were for non-capital offences, from culpable homicide, where sentencing ranged from 12 months imprisonment to transportation or penal servitude for life, to a verdict of guilty of concealment of pregnancy, where the average sentence in this 10-year period was just 11 months imprisonment. In cases of child murder convictions, less than 5% returned a guilty verdict for the capital offence of murder, an offence that could feasibly result in an execution. By contrast, for the period where I've looked at male murderers, 1850 to 1914, over 16% of murder trials of men returned a verdict of guilty for murder for the capital charge. So at this very early stage, it's clear that a comparative approach to even such a gendered crime as child murder or infanticide can provide revealing results, ideas of gender, criminality, and the operation of the criminal justice system. In the very final part of this paper, I'm going to look beyond infanticide to other forms of female violence. So in Glasgow in 1853, there was what was termed at the time the New Vennel murder. In this case, a ship carpenter, Alexander Boyd, was enticed back to a flat in New Vennel by some young women. Whilst in the flat, he was given whiskey that had been drugged by a woman named Helen Blackwood, the apparent intention being to incapacitate him so that he could be robbed of his possessions and clothes. Now, a Glasgow Herald Press report on this case stated that crimes of robbing and stripping are, we have reason to believe, of lamentable frequency in Glasgow. It is the nightly duty of a set of villainous harpies to waylay tipsy men while they are staggering along the streets under the cloud of night. They are partly coaxed, partly forced to the secret abodes of thieves, where they are rendered insensible, robbed of money and watch, stripped of their clothing, and carried to the street, where they are left to the care of the police. In the cases where the women will not partake of liquor, he is brutally mistreated by the male associates of the women, and the robbery and stripping invariably follow. Now, in the New Vennel case, the plan backfires somewhat. Boyd is still conscious after being drugged and makes a bid for freedom. And at this stage, we have the first instance of physical violence. So according to witnesses, Helen Blackwood hits Alexander Boyd across the head with an earthenware pot, rendering him insensible, before the other inhabitants rob and strip him. For reasons that aren't completely clear, Boyd is then thrown from a 3-story window and dies of fatal injuries. At trial, Hans Smith MacFarlane, Helen Blackwood, and Anne Marshall are convicted of Boyd's murders. They're all convicted on the capital charge of murder. But the Solicitor General for the prosecution stated in his closing arguments at trial, as regarded MacFarlane, he was the only man present, and there was nothing in the case which could remove from him the guilt of murder. As regarded the women, they one and all participated in what took place. The one drugged the liquor, another stripped the man, and the others assisted in throwing him over the window. Perhaps the jury could find extenuating circumstances in the case of the women, if they thought that without the aid and concurrence of MacFarlane, this diabolical occurrence would never have taken place. But he had no other duty to discharge than to call for a verdict of guilty against all of them, whatever recommendation the jury might offer in behalf of the female prisoners. Now, what's interesting here is that there is a suggestion by the prosecution that they may offer a degree of leniency towards the female accused. Indeed, the jury do accompany their verdict against Anne Marshall with a recommendation of mercy, though without supplying a concrete reason for doing this. And despite little obvious public sympathy towards the three convicted of murder, Anne Marshall's sentence was indeed commuted by Lord Palmerston, the Home Secretary, from execution to transportation. And this prompted a backlash in the press, in the local press, who asked whether it may be that the Home Secretary thought it too much to hang two murderesses at once. Another press article links this extension of mercy towards Marshall to the wider judicial treatment and punishment of violent women. And I quote, "The mysterious and deep-seated feelings which the difference of sex always creates seems to have secured an immunity from capital punishment for women, even when the most perverse ingenuity can suggest no extenuating circumstances. Of 3 women convicted of capital crimes who have just received reprieves, 2 seem to have been as proper subjects for the extreme penalty of the law as it is possible to find. The murderess Anne Mitchell, one of the principals in the horrid murder at Glasgow, when a man was killed by being thrown from the window of a brothel into the street, is to be saved from giving her life for the life she insisted on taking. Is it then to go forth that the measure of guilt is to be sought not in the wickedness of the intent, not in the cruelty and deliberation of the act, but in the sex of the perpetrator?" The press critique of the treatment of female murderesses in this case concludes with a reference to the Greek myth where Clytemnestra murdered her husband Agamemnon with the assistance of her lover Aegisthus. Clytemnestra must not escape when Aegisthus falls, nor the sacredness of human life be imperiled by leaving to the abandoned prostitute, the household fiend, or the unnatural and unsexed mother comparatively free license of slaughter. So there's some really interesting elements to pull out of this case. First, we see forms of female violence that very much deviate from the expected tropes of the desperate infanticidal mother. We see women as instigators of and active participants within violence in this case. We also see a suggestion by the prosecution, by judicial agents, that violent women should perhaps be treated more leniently than men, which is echoed by the actions of the jury and the Home Secretary. And then we see a pushback from the press, who critique a judicial response that seems, in their view, overly swayed by the sex of the perpetrator to the detriment of other factors. So just to conclude, as is often the case with projects like this at the very beginning, I've got more questions at this stage than answers. But these are some of the questions that are going to guide this project over the next 11 months at the end of this first 4-week period of this research. So did the type and severity of the violent offence that women were accused of affect their treatment in the courtroom and beyond? And if so, how and in what ways? Do we see judicial and societal responses to female violence differing? And if so, to what extent and in what contexts? And finally, and perhaps most crucially, were judicial and cultural responses to violent women mediated solely according to their sex, or were there other factors at play? There was no universal male experience before the courts. Their status, occupation, socioeconomic background, ethnicity, and other factors affected their treatment before the courts in notable and interesting ways. Was this the case for female offenders as well? Or was there a measure of truth in the commentary I just referenced, that the measure of guilt was determined by the sex of the perpetrator? So thank you very much for listening, and I will attempt to answer any questions that you have.